Welcome back. This is Legal Prophet, and we are still proceeding with our jurisprudence one, and we are going to look at the topic known as the popular justice system and the judicial system. So, what is the popular justice system? So, the popular justice system, this is the formal participation of the people in the justice administration. So basically the popular justice system, it involves the people. With the ordinary people, we are not the judicial officers, but we are involved in what we call administration of justice. So this popular justice system was so much used during the African traditional society, and where we see it was so much done with the clan heads and the religious leaders by then to solve some clan disputes without going to the formal court system. Remember, by then there was no formal court system until the year 1902. That is the reception clause and introduction of the High Court in the year 1920, if I can still remember, order in council. So this system was so much seen in our African traditional system, where the people were directly involved in the administration of justice through majorly the clan heads, among others. So we also see it even in the West. Before the coming of the formal courts, there was the popular justice system in the aspect or in the form known as the jury system, or the assessors, or the justice of peace system, where the lay people were always invited to decide on minor offenses where no paid magistrate existed. So the justice of peace system, lay people in England or in those systems or in the Western were always invited to decide on minor cases where no paid magistrate existed. So the difference between the popular justice system in the African society and in the Western society was the degree of formality attached. You're going to see that for the Westerners, there was some kind of formality or civilization, which was not the same with the Africans by then. So we are going to see that this involvement of the lay people and administration of justice to court was seen in the case of Fred Sabanshi versus Uganda. Even today, we have seen its importance or its relevance as per the case of Fred Sabanshi versus Uganda. So all that is still the importances or some kind of the development of the popular justice system in Uganda. Also, student of jurisprudence should know the ways through which the popular justice system emerged. So we are going to see that at first it arose as consensus of the community in need of justice. So the community could sit down and agree in order to come up with justice. To the modern times. So the modern times today, the popular justice system has been created as a result of a statute. So today it has even been created as a result of statute. So examples of the models or the modes of popular justice system. We have to know the different kinds of through which popular justice system has been seen. One, we are going to see it in the LC1 courts of Uganda that are governed by the Local Council Act of 2006. There is what we call the Amnesty Commission of Uganda. All that is trying to show the people's involvement in the administration of justice. There is also what we call the Gacha Quotes of Rwanda. We are going to see what the Gacha Quotes are. There is also the Truth and Conciliation Commission of South Africa. So we see the LC1 courts in Uganda, the Amnesty Commission of Uganda, the Gacha Quotes in Rwanda, the Truth and Conciliation Commissions of South Africa. All those are trying to show the different modes of popular justice system courts in Africa. Then we also have to know the legal basis of the popular justice system in Uganda. What is that brings the legal basis in Uganda? Look at Article 2 of the Constitution. Look at Article 126 of the Constitution, where justice shall be done with the wills and aspiration of the people. Look at cases such as Osotrako versus Attorney General. Look at articles such as 127 of the Constitution. Look at objectives 5 to 10 of the objective principles of state policy. All of those are trying to show how or the legal basis of the popular justice system in Uganda. Should also or should as well also acquaint himself with the main features or the characteristics of the popular justice system. So the popular justice system, whether it is formal or informal, it must involve the people or the lay people in administering justice. That is the first. So the second, the sources of the rules of popular justice system are customs. So customs majorly are used. Those are the major sources of the popular justice system, the customs, aims at reconciliation. So the main aim of the popular justice system is reconciliation of the parties in the dispute. So those are some of the main features of the popular justice system. One, whether it is done by formal courts, people must be involved. The sources are customs, and it aims at reconciliation. Also, students should know the role of community participation. What is the role? What is their role? What is the importance of the people or the community to participate in administration of justice? So one, these people can direct courts on a particular conduct or conception or attitude. Remember, we can say that a person who has killed looks like this. So they can guide court on that if the court has not seen. Two, it enables the community own the decision taken by the court. For example, if a decision has been taken by the villagers will say, it is our own people that decided this. They will take up the decision and own it. It also helps in the healing process. Remember, it aims at conciliation, one of the element. It aims, all the features, it aims at conciliation. So, where the people are involved in justice administration, it will help the community in healing or in the healing process. It also plays the role of addressing fundamental causes of the crime. The people can as well know the causes of such and such a crime. So when they are involved in administration of justice, it will help in addressing the fundamental causes of the crime. So those are some of the roles of the community in participation of justice administration. However, you should as well also know that this system does not only have good things. There are some problems, there are some bad things that are involved with the popular justice system. Let us briefly talk about them. One, where it is not controlled, it can come into mob justice. For example, if a person raped and the community is deciding, where they fail to control or regulate it, mob justice can arise. The people can easily go out of order and kill someone through mob justice. There is the aspect of pinpointing the accused. Remember, there is the principle of innocence until proven guilty as per Article 28 sub Article 3A. You are innocent until proven guilty. But in popular justice system, there is a lot of pinpointing to the accused. You did it, you did it, you did it. So that is a problem, delaying justice. Independency. Some people are not independent. There is no independence at all while deciding in popular justice system. People will come with their own sides. The people will decide, will come already having decided that this one committed. So there is no independency. There is the aspect of corruption and bribery. The people who decide, these are the lay people, can be easily corrupted by the rich people and end up not delivering justice as required. Feelings. People can decide based on feelings. There is a lot of feelings, attachment. Remember, in the formal justice, a judge does not own a case. That's why we see that even where you are about to own a case or be involved, you can easily step down and say, no, I cannot handle such a matter. There is wastage of time. Deciding is not easy. There is no decision, or a decision cannot be taken in time. So there is the aspect of delay in decision, wasting time. So we should also know the role of conciliation. What is the role of conciliation in the popular justice system? The role of conciliation, one, it enables in making peace between the parties. So while we conciliate as being the feature of the popular justice system, one, there will be enabling the making of peace between the parties. Two, rehabilitation of the affected, rehabilitation of the victims. Two, unity and peace. When you reconcile, you unite, and then there will be a peace. Then we go to what we call the problems associated with the reconciliation. There are also certain problems that are associated with reconciliation. Sometimes reconciliation is good. One, it ignores the rights and freedom of justice disposition. It ignores that. So also reconciliation is not very good. As we still proceed with our discussion for popular justice system, now we are going to analyze the different courts and know their aim in Uganda. So we continue with our different courts, and we are going to look at what we call the local council courts. So the local council courts, these are courts that exist in Uganda, and they can be traced from the NRM, that is in the 1980s to 1986. So before there, His Excellency Museveni had to come up with the aspect of how should we deal with matters. So he had to come up with that court, so which later had to be transformed into the local council courts by virtue of the 2006 Local Council Courts Act of 2006, which was a creature of Article 127 that gave Parliament power to enact laws to enable the people in the participation of justice administration. So that Article 126 gave Parliament power to enact laws that will deal with enabling the people or guiding the people on how to administer or to how to participate in justice administration. You also look at the different objectives, such as objective number 2, number 5, and 10 of the state objectives in our constitution. So basically, that's how this act came up. So I mean, this act and the court came up. So after we've known this, we should also know its composition, its qualification of members, its jurisdiction and appeals. So we should proceed by knowing the composition of this court that is seen in Section 8 of the Local Council Courts Act. Composition can also be known as the quorum. So the quorum, as per Section 8, subsection 4 of the Local Council Act, can either be at the village or the parish level. 5 members, where it is at the village or parish level. If it is at the village or parish, 5 members including persons presiding, 2 of whom will be women. So at the parish or the village level, 5 members form up the local council court, and 2 of which are women. Then where it is at the town level, division level, it shall be 3 members and 1 being a woman. So the quorum shall always be maintained at every sitting. And when you look at Section 8, subsection 5 and 6, where the quorum is not proper, as we have said, 5 members at the village or 3 members at the town, then that meeting shall not go on, or that court shall not sit, but rather they will have to adjourn and shall be adjourned to another day until the aspect of quorum is followed. Then we should know in voting, where it is voting, Section 8, subsection 8 of the same act, that is the Local Council Act, tells us that it shall be a decision shall be based on the majority vote, and where there is an equal vote, there shall be, or the chairman shall have what we call a casting vote. Chairman shall be having a casting vote, and while granting everything or while deciding on a particular point in these courts, you don't have to follow the normal laws, but rather natural justice shall be used or shall guide these people as per Section 24 of the same act. And as I've told you that no technicalities or legal rules or evidence or procedures shall be used in these courts as per Section 23 of the same act. You should also know how they appoint members to sit or to form the quorum. How do they appoint? So the appointment of a person to sit on the local council court shall be seen in Section 5 of the Local Council Act. 1, a person must be a resident of that area. You cannot be a member of the local council unless you are a resident of that area. 2, you must be of high moral character or standard. You must be knowledgeable in English and the local language at all. So if I don't know Lunyankore, I cannot be a member of the local council in that area. Know English and know some local language of that particular. You must not be a member of parliament or any other statutory body, and should not be a member of another local council. You cannot be a member in this local council and at the same time be a member in another local council. So those are the qualifications for appointing: know English and the local language, not a member of parliament or another statutory body, knowledge of English and the local language, high moral character, and you should be a resident of that particular area. Then we should also know the jurisdiction. What is the jurisdiction of the local council courts? The jurisdiction, remember, we have to know the territorial and pecuniary jurisdiction. With territorial jurisdiction, it is the local council only has jurisdiction to a particular locality in its area, only to that area. If the LC1 is of maybe our let me say in Chibuli, it only has jurisdiction over matters in that territory. Then there is what we call pecuniary. When you look at the second schedule of the act, that is the Local Council Act, the pecuniary jurisdiction shall be 20,000 in matters that are involving debts, contracts, assault, battery, damage to property. So the pecuniary jurisdiction in matters of the second schedule shall be 20,000, and they include debts, contracts. So assault, battery, damage to property, all those. So we also have to know the jurisdiction of the local council in regards to the other legal matters such as customary land. So this pecuniary, the local council court has jurisdiction in customary land, whether it exceeds pecuniary jurisdiction of 20,000. Any matter involving customary land shall be handled by the local council courts. The aspects of marital statuses or parental children, customary heirs, all those can be still handled by what we call the local council courts. Then we have to know the different appeals. How do you appeal in the local council? So you go and see that appeals from the local council courts, you can appeal, that is the local council court LC1 can appeal to the local council LC3, and the local council LC3 can appeal to the magistrate grade 1 or the chief magistrate, as per the case of Yona Mutata versus Patrick Ntwaluma. Yona Mutata versus Patrick Ntwaluma. That case tries to bring out the aspect of appeal in local council courts to be local council 1 appeals to the local council 3, and the local council 3 appeals to the chief magistrate, as per the case of Yona Mutata. We proceed with our discussion in what we call the popular justice system. So the other court that can be seen in what we call the popular justice system is what we call the Gacha Quotes. Gacha can be spelled as Gaca quotes. These quotes, Gacha means, it is a Rwandan word that means open air debate. So these quotes existed in Rwanda during the colonial or the pre-colonial eras. So we're going to see that by then the different clans that had misunderstandings would sit in public and air out their views and how could they solve their problems. And by then the leaders or the clan leaders were to act as judges. So you're going to see that because of the harsh or the Rwanda experiencing the much genocides and massacres, such as the genocides of 1959, 53, 63, 64, 73, 90, among others, genocides, this was seen, or the Gacha courts were always held or helping to solve the problems that were affecting these people. So these courts also had some challenges, and we see that there was no dispensation of justice based on based on natural justice. There was not, or it was not reconciliatory in nature. There was basically some problems that were affecting these courts. So that's why we see that since they were used in the pre-colonial era, then we have to know how did the Gacha courts now, how are they manifest today. So we look at the legal basis of the Gacha courts in Rwanda today. The legal basis of the Gacha courts today in Rwanda can be seen in the Organic Law number 8 of 30th August 1996. The Organic Law number 8 of 30th August 1996 provided jurisdiction to the Gacha courts to prosecute genocide and crimes against humanity. So these ones, they are trying to show that today, even in Rwanda, the Gacha courts are used in deciding or prosecuting matters of genocide and crimes against humanity. There is also what we call the Law Decree number 9 of 7th July 1980. The Law Decree number 9 of 7th July 1980 provides for the jurisdictional and competence of the Gacha courts in Rwanda. That decree tries to show us what is the jurisdiction of these courts and the organization of these courts in Rwanda. So the Gacha courts, a student should also know how does this court operate. So this court operates in a manner of system of chiefs. You appoint chiefs to sit as judges, and you also choose the people from the community to come and give their verdict on a particular point. And the central issue is not to punish, but rather to reconciliate. So basically, the courts are allowed to lessen sentences to victims, so they have the right to lessen and also forgive the people or the victims. So there are certain criticisms concerned with this court. One, there is no legal representation. A person cannot be represented. The judges lack proper training. All these are criticisms or things against or affecting the court. There is also partiality of judges. Some judges are partial while deciding in such courts. So when you sum up, that's what we call the popular justice system in Uganda and Africa at large. Thank you.